All right, now we're going to talk about defenses to negligence. So what are some things that you can do if you have been sued for negligence? What are some things that you could show that might get you out of this liability? So what we're going to talk about first is contributory or comparative negligence. All states have some form of this, but you have either contributory or comparative negligence. You don't have both. It's one or the other. So let's talk about what those are. Contributory negligence is when the other party has in some way contributed to the accident, contributed to the harm that occurred. So if we have a car accident, let's say it's a left turn car accident, and we know a lot of accidents maybe happen that way. So one person is turning left and the other person is coming from the other direction, but they are speeding. Well, they're speeding, that's causing a problem. That's violating a statute. They're violating a duty to other drivers around there. So when the person makes that turn, even though they are negligent, the person turning left is always the one who's negligent, but the speeder has contributed to the accident as well. So that is contributory negligence. And in states that have contributory negligence statutes, they say that if you have contributed in any way to the harm, then there is no liability. It's over. Any type of contribution to the harm that occurred makes the other person, they get off scot-free, no liability. And as you can see, this is pretty harsh. You have been injured in some way, let's say, and now you can't recover for those injuries because you contributed just even a tiny bit to the accident. So a lot of states shifted to this comparative negligence concept. And comparative negligence is the idea that we're going to look at each party and how much they contributed to the accident. So if one party is about 60% liable and the other party is 40%, then we're going to just divide the damages that way. So the one party will be responsible for 40% of the damages and the other party will be responsible for 60% of the damages. This is a much fairer system, I think, because we are sort of dividing the negligence between the people, and we're not making one person to be responsible for everything, to bear the entire cost of everything, when both contributed in some way. Now, a lot of states have also adopted what we call a modified comparative negligence. And what that is they just require the defendant, the person who's being sued, to be at least 50% negligent. So if the jury finds that, let's say the person turning left was only 40% negligent and the speeder was 60% negligent, then the speeder is not going to be able to recover anything from the person turning left because they didn't meet that 50% mark. So a lot of states are requiring that. The defendant has to be at least 50% negligent, and then they will divide it between the two parties. Okay, and the majority rule is the comparative negligence. Now, we also have another defense to negligence, and that is called assumption of the risk. An assumption of the risk is when you have voluntarily done something and you know that you could get injured doing this, you are assuming the risk. So if you go rock climbing, if you go skydiving, you're assuming the risk. You know these are dangerous things to do. If something happens, you've probably assumed the risk. This also comes into play when we go to sporting events. If you go to a baseball game and you get hit by a baseball, you have assumed the risk. And most of the time on the back of your ticket, it will say that, things may come flying out of the stadium, you may get hit, you are assuming the risk. So anytime you voluntarily put yourself in a situation where you know what harm could occur, the other party could assert that you are assuming the risk, and that is a good defense to negligence. Now, as you can see on the slide, so we have the plaintiff showing liability, and then the defendant brings up this defense of either contributory negligence. Well, let's say it's contributory negligence, because this probably wouldn't come up with comparative. And again, remember, contributory negligence is a very harsh doctrine, because it means the person totally gets out of being liable because of just one little thing that the other party did. Well, we came up with the idea of last clear chance. And what that concept means is that the defendant, the person who's being sued for negligence, they had the last clear chance to prevent harm from occurring. And this is basically a defense to the defense of contributory negligence. So we're giving the plaintiff another shot at recovering some damages because we're saying the defendant had the last clear chance to fix things. And this usually comes up with car accidents. So if we go back to our car accident with the person turning left and the speeder, even though the person is speeding, let's say it's just a little bit over the speed limit, and the person turning left really had the last clear chance to avoid the accident. They could have not turned, they could have assessed the speed of the other person pretty accurately. It wasn't that much over the speed limit. Something like that, we're going to say, you know what, we're going to go ahead and let them recover. You're going to be liable for the damages because you had that last clear chance to avoid the accident. All right, so remember with the difference between contributory negligence and comparative negligence, if the defendant is 49% liable under contributory negligence, there is no liability whatsoever, even though they are very liable. But with comparative, they're going to pay 49% of the damages. And this is a little bit different if a state requires them to be at least 50% negligent, which some states do. But again, it just depends on the state. This is probably a good time to also note that negligence and tort law, again, it's always state law. This is never federal law. It's always state law. If it's tort law, it's state law. And that means that it's different in each of the 50 states. So wherever you are could have different requirements, different standards, and that kind of thing. So be aware of that. Okay, so a lot of times you'll see signs like this. This is a sign at an amusement park in Maryland that is just explaining that if you've contributed, they have contributory negligence, and so you will not recover. So you might see a sign like that, and that means beware. If you do anything to cause injury to yourself, you're not going to be able to sue them at all. Now at this point, I like to tell a story about something that happened here in Columbus to a young girl named Brittany Cecil. She was a 13-year-old girl who attended a Blue Jackets hockey game. And during the game, she was hit by a puck that came flying out of the arena. A player was trying to make a shot, and in fact, it just went out and it hit her in the temple. She was okay at that time. She was able to stand up and leave the arena. She gets to the hospital, and when she gets to the hospital, they did a brain scan. They didn't see anything wrong, so they keep her overnight. And then about 24 hours later, she's not doing well, and they do another brain scan, and they realize that a lot of fluid is building up on her brain. And as a result, a little bit later, she actually passes away. So she is killed by this puck hitting her. When the hospital did the second brain scan, it was just too late for them to do anything. Had they done a brain scan a little bit earlier, they probably would have been able to do some kind of medical treatment that would have helped, maybe would have saved her life. We don't know for sure, but that is a good possibility. Okay, so her family sues the NHL and the Columbus Blue Jackets. She is, in fact, to this date, the only death that has happened in a hockey arena, in professional hockey, from this. Her family sues, and eventually the NHL and the Blue Jackets settle with her family for millions of dollars. So they give a very nice payout to the family. The family also sues the hospital. I think it was Children's Hospital. I don't know what came of that. I don't know that that was made public. But my question is, what defense would the NHL and the Columbus Blue Jackets have in this situation? And hopefully you're thinking assumption of the risk. And in fact, they did. They had a very good case for assumption of the risk because it's right there on the ticket. You know, pucks may come flying out of the ice, and it is a risk that you take by attending a hockey game. So they had a great defense. They also had another defense, and it would be the concept of intervening cause. And that is when something has happened after your negligence, something else happened that may have actually caused the harm that occurred. And in this situation, yes, she was injured by the puck, but then she goes to the hospital. And when she goes to the hospital, they probably could have saved her had they done a brain scan more quickly, a second brain scan. They did one right away, but they should have done another one probably within a couple of hours. They would have seen that the fluid was starting to build up, and they could have taken some sort of care of her that would have helped. This is what we call an intervening cause. And it usually happens in a medical situation. Somebody's injured, but then the doctor does something that causes more injury or causes further harm. That is intervening cause, and that is also a defense that you can have in a negligence action. So as you can see, the NHL and the Blue Jackets had a really good defense, but they still settled with this family, and they settled with them for quite a bit of money. And hopefully you can understand why. Sometimes I'm sure that they felt horrible about this situation. They were devastated that a fan was killed while attending their game. I know that the hockey player that actually hit that shot was sobbing after the game. They could not even console him at all. So people feel really bad, and they just felt it was the right thing to do. They wanted to compensate this family in some way, even though they could have gone to court. They could have argued assumption of the risk, intervening cause. But does that always make sense? They would have looked horrible to the public, and I think they would have felt horrible doing it. So sometimes you make a business decision. You make an ethical decision, just what feels right, and you do what feels right. And I think that's what happened in this situation. But I wanted you to see how this works in real life, and that we have lots of situations. We probably have more negligence cases in the courts than anything else. So this is a very common kind of lawsuit.